This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hello to you, and welcome to Boomer Time. As you know, I'm your host, Nancy Kogar, and I am an elder law and estate planning attorney here in Tennessee. And as you know, if you've been around for a while, I am passionate about helping people become more aware of all those tools they need as they age. And as you know, don't you know, this show is aimed at helping all of us become better prepared for the issues that come with aging. So today we are talking money, money, money. And a big part of my practice is planning. So, as I said, money is a big part of estate planning. It is such an important topic. Not only can money make you more comfortable, at least in some respects, right? Sometimes it can make you pretty uncomfortable. But more often than not, money, when it comes to legal issues, is at the root of a lot of disputes. Either you don't have it, or you do, or someone else is trying to take it from you, right? When you die, the worst case scenario is that everyone around you is fighting over what you left behind. Well, I hope to offer some wisdom when it comes to money and planning. So here are 5 topics that I'm hoping to move through in today's episode. 1, it's important to know that there are different kinds of assets. I know that seems simple, but different assets pass differently at your death. And I want to talk a little bit about that. That's just important for you to know that. 2, talk about some simple things that you can do to plan for that. Now, I want to show you some simple ways you can take some action just all on your own to have these assets pass simply. 3, you need to talk about expenses. I know some things seem scary, maybe estate planning expenses, but you need to make those now. And I can tell you, they will help you later in life. They will, and you may regret it if you don't do it. 4, what not to do with your money. There are a lot of them. And 5, I want to touch on some brand new rules from the IRS related to inherited IRAs. This is news you need to know, so we're going to talk about that. First, I want to talk about the variations in different kinds of assets from an estate planning perspective. As I said, this is important, and you'll see why in a minute, okay? So, like I said before, assets are all different. Some are personal, some are real property, some are tangible, some are intangible. First, I want to talk about real property. So this is something that can pass in a number of different ways, and it really all just kind of depends on how it's titled at the person's death. So when I say titled, I mean, what does the deed say? If it's held between spouses, then generally it should pass automatically to the surviving spouse without any action. So if it's held as joint owners with rights of survivorship, these would be people that aren't spouses. It has to specifically say joint owners with rights of survivorship. Then the same thing would happen. It would just automatically pass to the survivor. One joint tenant dies, then the survivor inherits that interest. You think about that, though. If you're planning for it to go somewhere else, you maybe want to look at how that property's titled, right? Because you can't give away something you don't own. So there are all kinds of different ways to hold real property. You can hold it in a trust. If that's the case, then that real estate will pass according to that trust agreement. And you can be creative in the way that works, but you want to make sure you understand what it says. You'd be surprised at how many people don't even know what a trust that they created years ago provides for. You can also hold property, real property that is, with individuals, numbers of individuals, as tenants in common. And these are simply kind of separate shares or interests that would then vest in your estate if you passed away or your heirs at law. So you would require some administration as to that interest. And here's something else, okay? So if you are a sole owner in real estate, that makes things a little bit more interesting, okay? So Tennessee law provides that real estate should vest in your heirs at law at your death. So if you don't otherwise provide for your property in a last will and testament, that's what's supposed to happen. But I'll tell you, even so, it will require some doing to get it conveyed to those heirs or sold, mainly because of all the fraud that we see today. I deal with title companies all the time, and it takes some effort, especially if you're going to sell it. So if you are the sole owner and provide for it to be disposed of in your will or direct that way, it will be sold through your estate. Otherwise, you're going to need some different kind of action outside of the court, probably an affidavit of heirship. There's some other things that you're going to need to talk to a lawyer, maybe me, about. But as you can see, this is very complicated, okay? I was just talking about one subject, real estate, and look at how many different options there are. So, all right, I'm going to take a break because I know this is dense stuff today. Dense. And when we come back, we are going to talk about other kinds of assets and some information I think will be helpful to you. So stick with me, okay? I'll be right back. Welcome back to the show. This is Nancy Kogar, and you are listening to Boomer Time. Today we are talking about money, old Benjamins, green stuff, moolah, and different kinds of assets. What else is there, right? It's got all kinds of names, and it can cause all kinds of trouble. So people want it, or they don't want it, or they spend it, they can't keep it. I tell you, it's the stuff that good stories are made of, and I've seen a lot of stories related to money. But today we're talking more specifically about different types of assets, including money. But, we talked about real estate before the break. You saw how it's titled can cause big issues as far as how it passes. And, these property, even liquid property, has different characteristics which can cause them to pass differently at your death. So this can really lead to complications. And it's something that really needs to be looked at while you're working on your estate planning. And as part of my estate planning worksheets that I have you complete in preparation for our strategy sessions, when you come to me for estate planning, I ask a lot of these type of questions not because I want to know how much is in your bank account, okay? I want to know what the character of your assets look like. What do you have? It makes a difference. It makes a difference. Is everything in one bank, or is it in 5 different banks? Do you hold everything in one investment account? Do you have multiple real estate? How is it held? Is it in different states? All this stuff is important. Do you have a business interest? There's something that gets missed a lot. So this is the reason I'm asking for these things. It used to be, folks would hold money in a number of different banks. I think that was a holdover from, the Depression era. You don't see people doing that as much anymore, but I still see it. I'll get a probate and we'll see $500 here, $1,000 here, $10,000 in this account. They'll spread it over different bank accounts, and the assets can also go missing because of this. And that's just simply because, there may be a random account that just is not used much, and the family doesn't know about it. It's forgotten. And as I've mentioned before, there's a registry online, state of Tennessee, every state really, but state of Tennessee, billions of dollars in unclaimed assets because of this kind of stuff. So you can do a search, see if you got some money there. I think I did at one point, and I think I had $47.26 or something like that was left over from an account that I had. So, hey, $47 can buy me dinner somewhere, right? So, anyway, so other kinds of assets. Let me get back to the topic. So we're talking about assets. I'd like to talk first about life insurance policies. There is some confusion about life insurance policies. These are usually beneficiary driven. Essentially they're contracts. So there's an individual or individuals that you list as a beneficiary on the policy. And then if the policy becomes ripe for a claim, i.e. when someone dies, you just make a claim. That person who's the beneficiary makes a claim, usually requiring a certified copy of a death certificate and a completed claim form. And the result? A check for whatever the policy death benefit was will be paid to that individual from the insurance company. Come in the mail, sometimes they'll direct deposit it. It doesn't typically require any court or probate administration. Now, it's never that easy. So if there is no beneficiary, or say the beneficiary is deceased or died before the owner of the policy, and the owner just didn't update the beneficiary designation, this happens too. And what happens in that scenario, say you don't have a will, but you had a life insurance policy and you didn't update the beneficiary information, it'll get paid into your estate, but, it is possible then rather than it being paid to one person, it'll be split between all the surviving lineal descendants under an intestate or estate without a will after first being subject to the claims of creditors. So that doesn't sound like a good option to me. Let's talk about bank accounts. So this is kind of a hybrid of some of the things I mentioned already, kind of like real estate. Okay, so if you have a jointly held bank account, then in Tennessee, it will vest automatically, or as we lawyers say, by operation of law in the survivor at the other's death. That means, their spouses on an account and one spouse dies and the other survives, the account will vest in the surviving spouse. So there'll be really no need for further action. But remember that you need to update that information, because if the other spouse passes away, then you've got an issue with where that money goes thereafter. And that brings me to my next point. So those bank accounts can have what are known as POD or TOD designations. What in the world is that, Nancy? Those are similar to beneficiary designations. It essentially means that the balance on the account is POD, payable on death, or TOD, transferred on death of the owner to someone. That's kind of a simple way to vest that interest beyond, the death of the second joint owner. But as the law works, a word of warning. Okay, do not put one child, if you have a number of children, do not put one child as a POD or TOD designation on a joint account at the exclusion of the other children. I see this too, where they said, Mom said, Joey will take care of it and do the right thing. Don't do that. This can cause big problems because of what I just talked about. On your death, the account or whatever was in it will become that one child's property. That's Joey's money now, okay? So that puts that child, Joey, in an awkward position of trying to figure out how to gift it as his property or otherwise transfer it to his siblings. And if he's got creditor issues or alimony issues or child support issues, that is one sticky wicket. So, vehicles. This is an interesting one. Vehicles can be tricky. Typically, you don't need court administration to transfer title to a vehicle at death. But I will tell you, because I see it all the time, if you go to the title office, they will ask you for a death certificate and letters testamentary, which is what you get when you file probate. So explain that one to me. So it's a little more difficult, especially if there's a lien holder. You'll have to either satisfy the lien or move to sell the car, and pay off the indebtedness as part of the sale. So if the car is free and clear and there's a title, it should be simpler. But, back to the letters testamentary, then you got to get with me and there's a way around that. But for some reason, it's an issue all the time. So I guess it's one of my pet peeves. So trusts. Transferring money to a trust can be something that gets missed, believe it or not, when creating a trust. So I thought it was important to mention this, and it's something you should watch out for. So when I do trusts for individuals, I spend specific time with my clients, as I've said, on their finances and where their assets are, and oftentimes with their financial advisors, to make sure that the titling that we do is correct and is followed through. So, sometimes on the reverse side, with trusts that I have not done, but maybe they come to me for administration, I see people coming in with a trust after someone dies. And the problem is the trust was never funded. So what does that mean? It means they never put any assets in the trust. They never titled any assets in the trust. So essentially what they have at that point is an empty trust, but it's still a trust that needs to be administered. So typically you've got to probate a will if there's a will, and then fund the trust, and then conduct trust administration. I know that's not the objective when that was done back in the day, but believe it or not, I see that. I see it. So I'm going to take another break, and then when we come back, I'm going to talk about this new rule that was clarified by the IRS as far as inherited IRAs. It's complicated, but it's important, and I see it come up all the time, so I just want to touch on it. Okay, be right back. Stick with me. Okay, so as I said in this second half of the show today, I want to talk about a new rule that just came out from the IRS, the Internal Revenue Service, and this is very important information because it relates to those retirement accounts that so many of us have, IRAs. Okay? Chances are, if you have one, and even so, maybe you've inherited one from a loved one, or even a share of an IRA from a loved one. It happens all the time. Well, you're going to want to listen up, okay? I'm telling you, this just came out, and this is exactly the kind of stuff we deal with in estate planning, and the reason that so much of the time I'm also involving a client's financial advisor in some of these conversations that we go through. Okay, so here's the bottom line. The IRS has finally made a ruling as to RMD regulations. So if you're older and you're listening to me, you know what I mean. RMD, required minimum distributions. These are the minimum amounts of money that you are required to withdraw from these accounts every year once you turn a certain age. So usually that's around 72 now. So these distributions start annually thereafter. And of course, when you start pulling this money out, it's considered income, right? And it's subject to income tax. These were tax deferred monies when you originally put them in the IRA, and now as you withdraw them, they're subject to tax. So that's very basic information as to how these retirement accounts function. Well, so a few years back, Congress passed something that was known as the Secure Act, and it was followed by another version of the same law. It was called Secure Act 2.0. Essentially, what that did was put new guidelines in place when it came to inheritances of IRA accounts when someone passes away. So that's why I'm bringing this up today. So, in other words, say your father, had an IRA, and he was taking distributions from that account over the years since he was 72 years old. So he passed away, say, at 82, and so there were 10 years of distributions. And the balance of what is left in that account comes to you as his beneficiary. Okay, that's the scenario that we're looking at. And let's say there's still $500,000 in there. All right. All this is very specific as well. Of course, the amount may change, the beneficiaries may change. If you do have one of these accounts, make sure to always have contingent beneficiaries, because the default is your estate. And estates are also taxable entities, so that could cost you a lot of money. So under the Secure Act, back to what I was talking about, a recipient of an inherited IRA. So let's go back to my example. Say there's $500,000 sitting in your father's IRA, and at his death, that passes to you. So that's an inherited IRA. That account can be rolled over to you. You don't have to cash it out. You could. You have an option to liquidate it, but if you do, you're going to pay taxes on all that money all at once. So that's the option, that you can stretch that account over 10 years as a beneficiary. And that, the aim of that was to reduce the amount of tax so you could better plan in terms of your overall income. Well, guess what? Guess what? So these regulations are now confirming that the annual RMD requirement applies to these beneficiaries. Okay? So the 10-year deadline will not be extended. So this means if you inherit a retirement account in 2020, you have to take it all out by the next 10 years, whether or not there were any required minimum distributions previously. So, it limits the flexibility that you have. And, it's clarified some of the distributions. So I don't want to get too into all the minutia of it, but because it is complicated, but it's important. I always want more money to stay with you than going to the IRS, I should say. But, this is something you're going to want to talk to not only your financial advisor about, but your accountant and also your estate planner. So this is why I think it's a good example of why you need to have all these folks involved in your estate plan. I always like to bring this home to have some real life scenarios so you can kind of relate to some of the circumstances where some of these things that we've talked about today came up. So I've got a couple of those. And I think these would be beneficial for you, because I don't think any of these guys thought that this would happen. I think they were just thinking it was convenient. And I know some of them thought, well, I'll just take care of it later. And later never came. But it created big problems. So one of them, the first one, this was a recent one actually. And it didn't occur to me at first. But then I started to think about it and I thought, that caused a big problem for the daughter. So there was some real estate that a husband and wife owned. They were both on the deed. Mom died first. Dad survived. Dad lived in the house at that point with son and daughter. They were all adults. And dad, I don't know whether son convinced him to do this, but dad went down an old quit claim and quit claimed the house to him and his son as joint tenants with rights of survivorship. Remember, we talked about that. Well, when dad died, guess what happened? The house became brothers, and sister got left out of the mix. So now she doesn't own anything. She lives in the house, but her brother is the one that owns the property. And, the property's worth probably almost $300,000 now. And she doesn't have very much. So I don't think that's what her dad intended on doing. But, that's a scenario where, something like that can happen. How about the one that I've mentioned already, where the second spouse, was married and she was not on the deed, and her husband had kids from a previous marriage. They had a house together, but she wasn't on the deed. He didn't have a will, and he died unexpectedly. Well, guess what? She got a child's share of their marital home. That was traumatic. So, and the house got sold. Kids came in, started moving everything, and it was not a good situation. Here's one related to joint bank accounts. I talk about convenience. So I had a client that had a caregiver that they really trusted, and I don't think there was anything untrustworthy about this caregiver. But just for convenience sake, he put her on all of his bank accounts as a joint owner. Well, he meant to change it, and his will provided that his brother and his sister would get everything. And he provided for the caregiver, but in a different way. Well, he died, and the caregiver was still on the accounts. So we were talking a lot of money. $500,000. That was now her property. So that was not a good situation. Luckily, this lady was honest and we were able to sort it out, but got to believe that got the family's attention, huh? And here's another one, a final one for you. I have this friend, I think he's 94, and he lives up on Signal Mountain. He loves birds, okay? And he has provided a very generous bequeath in his estate planning to birds. And initially, he had everything going one way with the thought that they would take care of it for him. And he didn't realize that you can't give away something that's not yours. So we fixed that, and that would have been a very expensive problem. So he's very pleased that we were able to resolve that. So that's just a few examples of things that can come up, very unintended, but you have to be careful, right? So lessons learned, right? So I don't want to close today by just reminding you, if you have any questions about anything we've talked about today or any questions in general, you can always reach out to me. You can check out my website, nancykogar.com, and you will also find lots of resources there and information. I love resources, so I'm trying to get those out to you. You can also subscribe to our newsletter, Elder Law News You Can Use, and there's always hand-selected articles in there that are relevant to you. I mentioned this IRA change, stuff like that. You really need to know about. So go ahead and do that, and that's free. Okay. And if you like this podcast, do us a favor, like it, follow us on Apple Podcast, on Spotify, and even on YouTube. Better yet, I see a lot of you sharing this with friends. Thank you so much for doing that. Help us get more people on board so we can get more people better planning for their older years. Um, I just hope that that's what leads to this, and also builds community, as I said, because caregiving is hard. And I've said it before, and I don't know if I've mentioned it recently, but I do pray for all of you, and I want you to be encouraged by what we're sharing here. So, and I want to hear from you. So reach out if you get a chance, and I will see you next time, I hope. Okay, we'll see you next time. Have a great week.